Assalamualaikum warahmatullahi wabarakatuh. Morning to all of you in Indonesia and outside Indonesia. It is my great pleasure to welcome all of you to Socio-Legal Joint Conference, Resilience in the Time of Crisis, Justice, Access, and Participation. First of all, I would like to introduce myself. My name is Belinda, and I will be hosting this conference today. On behalf of the organizers, I would like to extend my warm welcome to Head of Center for Socio-Legal Studies and the distinguished speakers, Professor Melissa Crouch, Professor Simon Butt, Professor Yuzuru Simada, Dr. Jacqueline Fell, Dr. Imam Kuswahyono, and Professor Sigit Trianto. I also welcome all participants who attend this Brawijaya International Law Conference, which is organized by the Faculty of Law Universitas Brawijaya. Ladies and gentlemen, on this occasion, I would like to inform you to the agenda of the event. The opening remark by Head of Center for Socio-Legal Studies, and followed by the presentation that will be delivered by 3 speakers on first panel, and then 3 speakers for the second panel. And after that, we will open a question and answer session, which will be led by the moderator, Ms. Francisca Ayulistia. Ladies and gentlemen, to begin with, I would like to invite Head of Center for Socio-Legal Studies, Mr. Fahrizal Effendi, PhD, to deliver his opening remark, and the time is yours.
Thank you, Mrs. Belinda. Dean Faculty of Law, Universitas Brawijaya, distinguished speakers, participants, and colleagues, selamat pagi waktu Indonesia, goedemorgen in the Dutch time, Ohio in Japan, and good afternoon in Australian time. Assalamualaikum warahmatullahi wabarakatuh. On behalf of the Center for Socio-Legal Studies, Brawijaya Law School, let me first extend my appreciation to all of the committees from Brawijaya Law School, especially for 2 strong and brilliant chairwomen, Prisca Listiningrum and Diah Prawestri Maharani, for co-chairing Socio-Legal Masterclass and today Socio-Legal International Conference. This event would not have been possible without support from other colleagues in Brawijaya Law School. We are so grateful to have you all. I am incredibly proud that we are organizing the 3rd International Socio-Legal Joint Conference in collaboration with 8 universities from 3 countries. From Indonesia, we have Universitas Brawijaya, Universitas Indonesia, Universitas Gadjah Mada. From Netherlands, we have Leiden University. From Australia, we have University of New South Wales, University of Sydney, University of Melbourne, and from Japan, we have Nagoya University. The theme of the conference is Resilience in the Time of Crisis, Justice, Access, and Participation, which will be held from today till tomorrow, 10 and 11 November 2021. Against this backdrop, from today until tomorrow, we will have 3 plenary sessions. As the kick-off, today we have Professor Melissa Crouch from the University of New South Wales, Prof. Simon Butt from University of Sydney, and Professor Yuzuru Simada from Nagoya University. They will deliver the presentation in the first plenary session on ASEAN constitutionalism in current authoritarian turn. In the second round, on national resilience in the time of crisis between security and human rights protection, we have Dr. Jacqueline Fell from Leiden University, Dr. Imam Kuswahyono from Universitas Brawijaya, and Professor Sigit Trianto from Universitas Gadjah Mada. And in the last session, tomorrow, on the future of legal education and legal profession, we have Professor Tim Lindsay from University of Melbourne, Professor Adrian Bettner from Leiden University, and Professor Sulistiawati Irianto from Universitas Indonesia. Apart from the extensive plenary sessions, we have also 12 panels discussing many issues from 66 presenters. On panel 1, chaired by me, we will discuss the Indonesian criminal justice system responses to the pandemic. On the second panel, chaired by Teresia Diah Wirastri, PhD, We will elaborate more on issues on family law during the COVID-19 crisis. Panel 3 on minority rights, stigmatization, and political identity will be chaired by Juni Arianto Kurniawan, PhD. Our expert, our colleagues from Barwijaya University, Milda Istiqomah, PhD, will lead a panel on the global threats and challenges in the context of the COVID-19 pandemic, terrorism, and violent extremism. Panel 4 on the functioning of courts in the time of pandemic, challenges and disruption will be chaired by Dr. Dian Rositawati. We also have Dr. Ken Setiawan from Melbourne Law School as a convener in Panel 5 on human rights in Indonesia's post-pandemic. Besides, Dr. Ricardo C. Parmata from Universitas Gadjah Mada will be chair Panel 6 on agrarian resources, position, disposition, and dispute. Panel 7 on gender participation in legal reform will be chaired by Lena Hanifah, PhD, while Dr. Stein van Haus will be chaired Panel 8 on law in context, interlegality, and the interconnectedness of local, national, and international legal orderings. We are also grateful to have Dr. Herlambang Wiratanaman, one of leading human rights activists and scholar, who will be chair Panel 10 on challenges to legal education in a changing landscape. We also have Dr. Widodo Dwi Putro, a chairman of AFHI, Indonesian Association for Philosophy of Law, as the chairperson of Panel 10 on the battle of paradigms in the field of legal research methods. And in the last panel on digital law and society in the era of COVID-19, we have Dr. Awaluddin Marwan, founder of heylaw.id. Learning from success of the last sociological conference in Universitas Indonesia, I believe that this third international sociological conference could play as a catalyst to our efforts to strengthen sociological research in Indonesia. I believe that by the end of this conference, all participants will have gained new knowledge and fresh perspective and made new and lasting friendship. I wish you a productive conference. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you, Mr. Farizal Effendi, PhD. And now we are moving on to main session. And from this now on, the session will be led by the moderator, Ms. Francisca Ayulistia. And without further ado, please welcome Ms. Francisca Ayulistia. And the time is yours.
Thank you, Ms. Belinda. Good morning, everyone. Assalamualaikum warahmatullahi wabarakatuh. Welcome to the third conference on socio-legal studies in Indonesia with the theme for this year, resilient in the time of crisis, justice, access, and participation. For today, we have a first session for the seminar. The theme is about the Asia Constitution in current authoritarian term. The first speaker would be delivered by Ms. Professor Melissa Crouch from UNSW. Second speaker would be delivered by the Professor Simon Butt from University of Sydney, and the last speaker would be delivered from Professor Yuzuru Shimada from Nagoya University. Without further ado, I will read the short biography or maybe short CV from Professor Melissa Crouch. Professor Melissa Crouch is Professor and Associate Dean Research at the Faculty of Law and Justice, UNSW. Her research contributes to the field of comparative constitutional law, law and society, and law and religion. She has been awarded numerous grants and awards, including the Edinburgh, Australia Research Fellowship, University of Indonesia Visiting Fellowship, and the University of Melbourne, Catalan. I'm sorry, maybe I pronounce it wrong. Catalan Fritz Prick Visiting Fellowship. And Professor Melissa is Chief Investigator on ARC Discovery Grant on Constitutional Change in Authoritarian Regime from 2018 to 2021. Maybe because of we a little bit late for today's session, I will give the time to Professor Melissa Crouch. Are you ready, Professor?
Yes. May I ask how much time I have?
20 minutes. Yes,
20 minutes.
20 minutes. Yes, after all of the speakers speak for 20 minutes, there will be a question and answer session. And each of you could maybe raise your hand if you want to direct asking question, or maybe you can write it in the chat box.
Okay, thank you. I might share the screen if that's okay.
Yes.
Can you see that? Okay. Great. First of all, thank you to the organizers, the organizing committee, to the Dean. It's fantastic to see the organization of this conference. I'd like to congratulate you on putting together such a fantastic program. And it's wonderful to see so many Indonesian scholars leading at this conference. So the theme of our panel today, as I understand it, is Asian constitutionalism and the current authoritarian turn. To some extent, I think of constitutionalism in Asia, because I'm not sure there is one idea or any common characteristics of constitutionalism in Asia as such. But I'm very interested in this idea of authoritarian constitutionalism. And in some of my work, I have emphasized what I see as some of the varieties in expressions of authoritarian constitutionalism. And I think it is not just current, but also has a longer history. And so I first of all want to acknowledge that, of course, much of the discussion today, particularly in Indonesia, is around the idea of democratic decline or democratic decay. And like many other countries around the world, there has been concerns of a reversal of the democratic process and potentially a reversal of constitutional democracy. And many scholars have tried to capture this idea through ideas such as authoritarian constitutionalism, autocratic legalism, or abusive constitutionalism. So that is, there is a sense that in some countries, Poland and Hungary are often ones that are given as examples, that the constitution is used in an abusive way or in a way that reverses democracy or goes against some of the very principles of democracy. So that's one kind of authoritarian constitutionalism. I want to talk today about a different kind of authoritarian constitutionalism. And this, I think, is perhaps a slightly older or more traditional type of authoritarian constitutionalism. And it is a way of acknowledging that in some countries, there has been a shift from military rule to different kinds of military rule, and that there may, that rather than thinking of it as a shift from constitutional democracy to authoritarianism, it's in fact simply been a shift from one type of authoritarian rule to another type of authoritarian rule. So the title of my talk today is based on a paper called Preemptive Constitution Making. So let me tell you something about this idea, and then I'll spend the rest of the time focused specifically on Myanmar and how we see this play out in Myanmar. And I'll say something towards the end as well about sort of post February 2020 and the military coup there. So this idea of preemptive constitution making is that authoritarian constitutionalism can be used to contain a potential transition to constitutional democracy. So that is, there is a sense that there are some actors who are pushing for constitutional reform, who are pushing for a more democratic and constitutional system. And instead, regime leaders use the constitution making process in order to limit that transition to liberal democracy and to strengthen the resilience of that authoritarian regime. So that's what I mean when I'm going to talk today about preemptive constitution making. What I'm going to do is show how that has played out in Myanmar in particular, and the way in which the military used this sort of concept of preemptive constitution making, if you like. It used the very idea of constitution making in order to strengthen its military state. So just by way of background, many of you maybe recall that in 2008, there was a devastating cyclone in Myanmar. It was one of the most devastating in recent sort of records and history in Myanmar. Many hundreds of thousands of people died. And even at that time, when the international community was offering to help, initially the military refused. So this was at a point when there had been several decades of military rule in Myanmar. And yet, several days after the cyclone, a constitutional referendum was held. This was a referendum of a constitution drafted by the military and under the control of the military. And despite this humanitarian crisis, they still went ahead with the so-called referendum that had approved, that allegedly approved and endorsed this constitution. So I say that to give some of the background as to how committed the military was to this particular constitution. So I've talked a little bit about the idea of preemptive constitution making already. What I'm going to do then is talk a bit about what I mean by this military state, or what is it that the military did to the constitution in order to preempt democracy. Well, first of all, I'll talk about how the constitution itself introduces the leading role of the military in the governance of the country. So very much the constitution endorses the role of the military as central to the country and to its political system. The second is I'll show how the military used an ideology that it had developed in the 1990s and effectively included that in the constitution as a way to shape the ideological focus of the constitution favorable to the military. And in Myanmar, that's known as the 3 national causes. And then I'll talk a little bit briefly about how the constitution is a highly centralized system, or what I refer to as cooperative centralism. So it is cooperative in the sense that the different institutions and branches of government are expected to cooperate with each other. So there is not a sense in which the different branches of government are in tension or competition with each other or independent of each other even. They are to cooperate, and it is highly centralized in the national government where the military has particular control. Okay, so going back a little bit, I've talked about Cyclone Nargis, but let's come to then, well, how did this constitution making process take place? In brief, there was an election in 1990, and although the National League for Democracy was successful, they were never permitted to take office. And so instead, the military insisted on holding a national convention to draft the constitution. Now, this took place in 2 stages, so in the 1990s, and then after a break in the 2000s. And then we come to 2008 with the referendum. And the pictures that you see there are of the former National Convention venue that I visited. And then this constitution was enacted in 2011. And of course, from 2011 to 2021, we've seen how that constitution operates and how the military is a part of the political system in Myanmar. So coming to the first part of this idea of the military state in Myanmar in particular, and how the military used this constitution-making process to affirm its role. So effectively, we have these 3 key points here, and the person, of course, who is currently in charge of the country, Min Aung Hlaing, you can see on the screen here. So this idea of the military as the leading body in the country comes from an idea that the military has developed over time that distinguishes between national politics and party politics. So what the military says is that, well, on one hand, there is party politics. This is the political parties that run in elections. The military claims not to be involved in party politics, although it does have the USDP, which is a party of former military officers. But nevertheless, the military claims that it is not involved formally in political parties and the elections. But nevertheless, the military claims to have a leading role in what it calls national politics. And the way that it justifies this distinction is to say that the military needs to be involved in national politics because of the history in the country of political parties fracturing and in order to ensure stability in the country. Now, in addition, there are two main ways that the military has influence. One is formal or structural constitutional advantages, and the other is informal advantages. So let me briefly give some examples. So one, or the most prominent example of a formal advantage that it has is that it has effective veto on any constitutional amendment. So over the past 10 years, we've seen that when the NLD has attempted, while in government, to amend the constitution, that has not been successful, in part because the military holds 25% of seats in the parliament. And according to the constitutional amendment rule, this means that you would need at least some support from the military officers in order to amend the constitution itself. So that's an example of its formal role. Its informal role, many people in Myanmar are familiar with the fact that often former military officers hold roles in different parts of the government administration. And so the picture that you see here, for example, is of a campaign that concerned the judiciary. So in around 2015, there was evidence that the military had been transferring former military officers into the judiciary. And so there was a Facebook campaign where people posted photos of themselves wearing a yellow ribbon in protest that the military was still continuing this informal practice as a way for it to gain influence over this branch of government. Secondly, the Constitution sets out this ideology, which, as you can see on the screen here, evolves around the non-disintegration of the Union, the non-disintegration of national solidarity, and the perpetuation of sovereignty. And interestingly, these three ideas were something that were taught in schools. It was on the radio, it was in the newspapers, long before this constitution was established, but then it effectively became part of the constitution and a way in which the military justifies for itself its role. So let me talk about those very briefly. First, this idea of the union is important to the military. It contrasts this with a federal system, or at least it has to some extent in the past, because federalism was seen to potentially lead to secession. Now, to some extent, that changed a little bit, particularly around 2015, where federalism began to be normalised in discussions a little bit more. But overall, the concept of a union has remained strong and a key part of the military's ideas. A second is this idea of national solidarity. So what does this mean? In Myanmar, the military claims that there are 135 national races or official groups. The country is just divided into 14 regions or states, so 7 based on minority ethnic groups and 7 Burma majority regions. And again, this idea of national solidarity hints at the concern to ensure that different minority groups do not cede from the union. And then third, this emphasis on sovereignty. And while, of course, most countries would emphasize their sovereignty in different ways, here this is a way for the military to position itself as the guarantor of territorial sovereignty. So here the threat to sovereignty is seen largely as a threat that is internal rather than external, and that it is the military's role to protect the country from any such threats. And then finally, coming to the third part of this constitution-making exercise and the kind of political framework it resulted in, is that this idea of the military state is animated by cooperative centralism. The map you can see on the screen, there's a red dot in the middle, which is effectively Naypyidaw, the capital city. And this is now where the capital city is located after having been moved from Yangon. To some extent, it's a visual reminder of the centralization of power in the military. The Constitution is very deliberate in ensuring that largely it is the president, as well as some other central elite political actors, that are responsible for making appointments, political appointments, as well as ensuring any accountability measures. So even though there are these 7 states and regions, actually it is the national government that has significant control over them, and the subnational units report to them. I suggest that particularly this relationship between state and region governments and the central government is one of based on coercion, where the subnational units are required to collaborate and are very much subordinate to the central government. And in addition, in effect, the military positions itself as something of a 4th branch of government altogether. And in this system, we have both the parliament acting somewhat unusually as a check and balance on the courts. And so the courts are not really an independent branch, and neither are they equal in status to the parliament or to the administration. They are effectively a subordinate branch. I'm going to skip through some of these other things because I think we're short on time. Perhaps I'll just say something about the past 10 years and the fact that one of the striking features of the last 10 years has been that there was a parliament, that it was quite a significant body, and that it did animate constitutional politics in Myanmar for quite some time. But it was very clear that it was also constrained in certain ways. And in this picture, if you look at the top left-hand side of the screen, where you see the members of parliament who are wearing dark green uniforms, those are the military officers. And it gives you something of a visual representation of the presence of the military, even in institutions such as a parliament, which, aside from the military representatives, is the result of elections. So to sum up on this and then say something very briefly about 2021, what I've suggested today is that the military has designed this constitution through a constitution making process in order to prevent a transition to democracy and to create and establish this idea of a military state. When we look at the constitution, we can actually see where power lies in Myanmar, and in particular that is embedded in the role of the military in politics. So let me just say something then about what's happened since 2021. In February 2021, there was a coup, and the military took over and did not let the National League for Democracy take office. So there had been an election in November 2020. The NLD had won that election. They were due to take office in February 2021, and yet on the very day they were supposed to take office, the military arrested many of the former members of government and prevented the new government from taking office. The reasons to do this are complex, but simply to say that, in fact, the military is using the constitution to justify this takeover. So, in fact, the 2008 constitution is still central to what the military claims it is doing and how the military is claiming to rule. Now, of course, since then, civil society has overwhelmingly rejected this 2008 constitution, and so to some extent its future is uncertain. But for now, the military is claiming that it will continue to rule until such time as it can organise new elections, and that those new elections will be held according to the 2008 constitution. Of course, this doesn't. This means that the future in Myanmar is particularly dark, and the 2008 constitution is widely discredited because of its authoritarian status, but also because of the fact that there is a sense that even the military has now violated the very constitution that it created. So I'll leave it there, and I look very much forward to hearing from other panelists and also questions from the audience. Thank you.
Thank you, Professor Melissa. I will remind all of you again, if you have any question, you can write it in the chat box. You can write it in the chat box, and we will have the session for question and answer. So maybe if you raise your hand, maybe later, after all of the speakers deliver their presentation. Thank you. And I will a little bit give like summarize, maybe not summarize, maybe something I learned after Prof. Melissa talking about the preemptive constitution making and military state in Myanmar. It's about how the military actually be the part of Myanmar political affair, how that the history, how they become the leading role in Myanmar itself, even in the formal role and informal role. Even from the formal role, they have effective veto in the constitutional amendment role. As we know, after a lot of things happen in Myanmar, military is really strong in Myanmar. After the coup in 2020, I think 2021, if I'm not mistaken, there's a lot of problem in Myanmar, and Myanmar, of course, military itself violate the constitutional that actually they are the one who create the constitutional is military itself. That's all from the first speaker. Maybe we will continue for the second speaker. The second speaker.
Abby,
Yes.
Abby,
I'm sorry, could you turn off the, yeah. Okay, I will continue for the second speaker. The second presentation will be delivered by Professor Simon Pat. Professor Simon Pat is a RRC, Australian Postdoctoral Research Fellow and member of the Center for Asia and Pacific Law at Sydney Law School. Prior to joining the faculty as senior lecturer, Professor Simon worked as a consultant on the Indonesian legal system to the Australian government, the private sector, and international organizations, including the United Nations Development Programme, UNDP, and the International Commission of Jurists, ICJ. He has published widely a variety of areas of Indonesian law, including constitutional, criminal, and environmental, and is particularly interested in corruption and decentralization in Indonesia. Without further ado, Professor Simon, are you ready? Yeah. Time is yours, Professor Simon.
Thank you very much. In your introduction of me, you said I was interested in corruption. That might be taken the wrong way. I'm interested in the studying corruption, particularly in Indonesia, but also more broadly. Thank you very much for that introduction, and thank you very much for inviting me today to speak in the first session of this, the third socio-legal conference. And it's been a great pleasure of mine to have been involved in the first two of these conferences. It's fantastic that these conferences have continued. It seems like we have a tradition growing here, and it's great to see that so many people are enthusiastic about socio-legal studies and indeed the study of Indonesian law more generally. Now, Melissa spoke about trends in Myanmar and spoke a little bit about Indonesia. My focus is going to be on Indonesia exclusively. Today's session, of course, is about authoritarianism, and it bears noting that many countries throughout the world, including Indonesia, think that some of the best medicine to prevent authoritarianism is effective constitutional or judicial review. If effective, constitutional review can help keep the exercise of legislative and executive power in check to ensure that one does not become too powerful and overwhelm the others. And this, of course, many of you will know, is the essence of the separation of powers in many countries. Interestingly, I suppose, particularly in the West, the separation of powers has been directed towards preventing excessive presidential or executive power rather than legislative power. But some might argue that in today's Indonesia, the legislature is the most powerful branch and is more likely to override the other branches than any of the other branches. Anyway, I digress. I've gone off on a bit of a tangent there. Now, back to judicial review or constitutional review. if the separation of powers depends largely for its effectiveness on the government complying with constitutional review decisions. And this is what I want to talk about today: government compliance with constitutional court decisions. In particular, at what point can the government say that it has complied with the decision? And another question, can a government actually do nothing and still comply with a constitutional court decision? Now, if the government can just ignore constitutional review decisions, then the court really can't limit the exercise of government power in most circumstances. But as we'll see, in Indonesia, as in other countries, the Constitutional Court has developed some ways to ensure that its decisions have some effect. Now, compliance with constitutional court decisions is a problem in many countries. Many countries have trouble, or courts in many countries have trouble ensuring compliance with their decisions. And some judges and even courts refuse or neglect to recognise or apply constitutional review decisions. It's important to note, though, that compliance will rarely be fully complete or fully non-existent. Compliance will normally occur somewhere along a continuum. And here, the degree of compliance usually depends on a range of factors relating to the court itself and the political circumstances and other circumstances in which it operates. Some of them I've got here on the slide. For example, compliance might be more likely if the court's orders are clear, and that's indicated by clarity of orders that point under factors affecting compliance. If the court's orders are confusing, then this might give the government a reason, or perhaps an excuse, to postpone any response to the court's decisions, perhaps even indefinitely. Much will also depend on whether the court can impose sanctions for non-compliance. In some countries, constitutional courts can engage court-appointed bodies or agents to supervise enforcement, or even issue fines or other reprimands for non-compliance. Compliance will also be, of course, more likely where it does not pose political or financial difficulties for the government. And if there are parties or observers that are able to monitor for compliance and publicise non-compliance. Much will also depend on the political and public capital a court has accumulated. So some would say that governments might be more expected or more open to complying with decisions of courts that are publicly popular. Perhaps they're publicly popular because of decisions that they've made that people think are of high quality. Some countries have an automatic expectation that governments should follow constitutional court decisions or court decisions in general. There's no question about enforcement. It just happens as a matter of course. Now, many of these factors affecting compliance are at play in Indonesia, and I think suggest that compliance will be low. The Constitutional Court, of course, as many of you will know, doesn't have any powers to compel compliance. It has no constitutional police or constitutional bailiffs to monitor and ensure that the government follows up on decisions. All the court can really do is meet its statutory obligations to send copies of its decisions to the DPR, the President, and the Supreme Court, and to include in the State Gazette its decisions that invalidate statutory provisions. So in this way, the government cannot claim not to know what the court has decided. They're informed of the decisions and then can consider how to respond. Now, if the government or some other entity continues to apply a statute that the court has invalidated, then this becomes a matter for the Supreme Court and the courts below it, such as the administrative courts. Former Constitutional Court Chief Justice has suggested, for example, that law enforcers who continue to apply provisions that the Constitutional Court has invalidated might be subject to a civil claim for an unlawful act based on 1365 of the Civil Code. Arguable, but I'm not sure whether such a case has been attempted, much less has been successful thus far. The main problem here is that other courts, including the Supreme Court, have been inconsistent in their recognition and application of Constitutional Court decisions in Indonesia. What of the Constitutional Court's political or social capital? Well, as many of you know, while the Constitutional Court's popularity has been high for various periods of its existence, it's also been significantly shaken by some corruption scandals and some ethics complaints. This hasn't happened for a number of years now, but the image of the court may well still be tarnished in the eyes of the public. And this might give politicians or the government ammunition in order to avoid responding to unpopular or decisions of the court which it does not like. And as to the last point here, clarity of decisions, the Constitutional Court's decision-making, I think, is generally better than many other Indonesian courts in terms of its clarity. But there are still various problems with the court's decision-making in some cases. It's not always clear what the court's decision is, and particularly the reasoning behind the decision. Now, I think that, in fact, there's another issue here at play in Indonesia. It's not just about the factors that the scholars in the international literature have mentioned that affect compliance. I think there's also a significant issue in Indonesia about who needs to do what in order to comply. And I would argue that there is actually some genuine legal uncertainty about this question. Who must comply with the Constitutional Court decision of Indonesia, and what must they do in order to comply? And what does Indonesian law say about these things? Well, of course, many of you will know that the Constitutional Court of Indonesia now tends to issue decisions that are called conditional decisions. So a court might not decide, or the Constitutional Court decides not to invalidate a law, but to say it will be unconstitutional unless it's interpreted in a way that the Constitutional Court mentions in its decisions. Now, this has invited a reasonably large variation in government responses, and I'll talk a bit about that in a moment. But just to go back a little bit, I became interested in this topic after reading a speech given by current Chief Justice of the Constitutional Court, Justice Usman, that he gave in January 2020 during a launch of the Constitutional Court's annual report for 2019. And he talked about findings that court-supported research into compliance had discovered. Only around 50% of the court's decisions in 2013 to 2018, according to this research, had been dipatuhi, followed by the government. Others, according to this research that Chief Justice Usman mentioned, were only partially followed. And about 1/3 appeared to have been completely ignored. Chief Justice Usman then urged the National Parliament and the government to implement Constitutional Court decisions by passing legislation, by amending the statutes that the Constitutional Court had declared unconstitutional. And he also warned those who were attending his speech, including President Joko Widodo and the Supreme Court Chief Justice Hatta Ali at the time about the dire consequences of this failure. He said, kepatuhan terhadap putusan mencerminkan kedewasaan dan kematangan kita sebagai negara yang menahbiskan diri sebagai negara hukum demokratis sekaligus negara demokrasi berdasarkan hukum. Sebaliknya, ketidakpatuhan terhadap putusan MK selain bertentangan dengan doktrin negara hukum juga merupakan bentuk pembangkangan terhadap konstitusi. He said, betapapun konstitusi merupakan hukum dasar tertinggi dalam bernegara, dia tidak akan berarti apa-apa manakala tidak ditegakkan dan ditaati. Jika demikian faktanya, negara hukum yang kita cita-citakan masih menjumpai tantangan berat. Only yesterday, I read another news report where Justice Usman made similar comments. And he suggested, even in that news report, that the legislature should also take account of the court's reasoning when it came to making legislative amendments, not just the holdings of its decisions. He said, bahkan ada pula putusan MK yang dalam amarnya menolak, namun pada bagian pertimbangan memberi pesan kepada pembentuk undang-undang untuk mengubahnya, untuk mengubah undang-undangnya. So he's saying, combined with the speech I just mentioned before, that the government or the legislature is not doing enough to comply with constitutional court decisions. I think that's the overall message. But one question I have is whether, in fact, it is necessary for the legislature to take action to comply with the court's decisions. And with respect to the Chief Justice, I think it's not always required. Take, for example, one of the court's most famous decisions, an early case where it removed from the legislative election laws the prohibition on members of the PKI or former members of the PKI to stand for election. Now, the court removed that prohibition from the law. It took away that part of the statute. What does the legislature need to do in order to comply with the decision? I would say nothing, because the court has already done the work for the legislature. Conditional decisions, I think, are particularly difficult. The Constitutional Court now issues more conditional decisions than it does just to membatalkan pasal-pasal, to invalidate provisions of legislation. But what the government must do, if anything, in response to them, I think is quite unclear. And I think the source of the confusion here is, despite the court's denials, these decisions do have the effect of changing legislation. And so if the legislature is quite happy with the decision and the conditions that the court imposes upon the constitutionality of the statute under review, it doesn't need to do anything at all. It can just allow the court's decision to change the legislation to remain as is. It's quite interesting, really, because one of the main reasons why the Constitutional Court started using conditional decisions was because it feared that the government was not or might not be complying with its decisions, with its kind of simple invalidations. The thing about, or one of the main or serious ramifications of conditional decisions is, I think, the obligation or the responsibility for compliance gets shifted from the legislature to the government. In the same way, for example, that legislation, statutes passed by the National Parliament, for example, need to be implemented in many situations by regulations. So too, I think, often do conditional decisions need to be enforced by various regulations. And we often see after a conditional decision is issued in Indonesia, various forms of implementation regulations or implementing regulations such as ministerial regulations, surat edaran, are issued in line with those decisions. So one of the ironies, I think, about the way that these types of decisions work is in its concern to avoid legislative non-compliance. The Constitutional Court now relies for the efficacy of its decisions on a wide range of actors being aware of its decisions and being inclined to follow them as they would follow legislation. Now, I don't want to spend too much more time than I'm allocated, but I just wanted to clarify, using an example, some of the uncertainties I think that arise out of compliance with constitutional decisions and what the legislature needs to or doesn't need to do in order to comply. Now, you will all know about the various decisions that the Constitutional Court has made relating to the 1974 marriage law. One of the most famous of these decisions was about the obligations of biological fathers to children born out of wedlock. The court in this case was asked to review Article 43, subsection 1 of the marriage law, which basically gave a child a civil relationship with the child's mother and the mother's family, but not the father. And so this meant that a child could seek support or inheritance from its mother, and only its mother's name would be on the birth certificate, but could not force or ask the biological father to pay maintenance and wasn't entitled to inherit. And as I just said, the Constitutional Court decided that it would impose obligations on biological fathers to look after financially any children that they had out of wedlock. Now, compare this case with another case, this time also about the marriage law, but relating to child marriage. I know there was a previous case in 2005 about Article 7.1, which contains the marriage age of 16, I should say, for females and 19 for males. In that 2015 case, the court mentioned lots of problems about child marriage, but was not inclined to change the marriage law to make the marriage ages equal or to increase the marriage age for women. But in 2017, the court was asked to reassess the constitutionality of Article 7, subsection 1, which contained the marriage age. And this time the court decided that the provision was discriminatory because it provided different ages, minimum marriage ages for men and women. Now, as many of you also will know, the court gave the DPR, the National Parliament, a 4-year deadline to change the policy and left the provision valid until the Parliament had an opportunity to change the marriage age. Now, the National Parliament did, in fact, make an amendment to the marriage law in 2019. What I think is interesting is in that decision, the court, in that law, in that amendment, the legislature responded only to the marriage age decision of the two that I've discussed today. And it made the marriage age the same for both men and women, 19 for both genders. But it did not make any changes to Article 43.1, which, as I said, was the provision that was reviewed in the case about fathers being responsible for children born out of wedlock. Now, what does that mean? Does that mean that following Chief Justice Usman's view that the National Parliament should have taken the opportunity to amend Article 43(1) to bring it in line with the court's interpretation? Or does it mean that the national legislature, in fact, simply agreed with the court and decided it didn't need anything to do? I think I'll just finish with those questions. Thank you very much.
Thank you, Professor Simon. So actually, Professor Simon talking about the enforcement of constitutional court decision and the separation of power in Indonesia, that actually the compliance between each of Indonesian government itself cannot be seen as in decision itself. But there are a lot of problems, as in Indonesia, there is no sanction for non-compliance, corruption scandal, controversial decision, clarity of decision. And there's a lot of issue, especially in the uncertainty we need to do in order to comply, we must comply, the judicial decision and how it's to be done. And every decision, he said that every decision, almost many of decisions from Indonesia constitution ignored by the government. So there's a lot of things in marriage law, especially. Maybe you can, from the participant, you can also ask the question to Professor Simon in the chat box, or maybe you can raise hand after the last presenter, Professor Yusuru Shimada. Professor Yusuru Shimada is professor from Graduate School of International Development of Nagoya University, Japan. His research interests are law in the peace building, Indonesian law, law and development, Asian law, comparative law. His current project are law and human rights in Indonesia, rule of law in the reconstruction process in the post-tsunami Aceh, and law and development. Professor Yuzuru, yes, time is yours.
Yeah, thank you, Francesca. So, and I'd like to share my paper. Okay, that's fine. So, thank you very much for inviting me to this very interesting session. That it's already third conference about the socio-legal conference. So, and I'm happy to meet my old friend Simon, Melissa, and Alpha. Farizar and etc. So today it is exactly 2 years since my last departure from Indonesia to Japan. So that means that almost 2 years I couldn't go to Indonesia, but now that because of this technological improvement, we can meet together. So even very from the long distance. So and then in Melissa's presentation, that she discussed about the constitution as a tool of the military government or the authoritarian government, and the Simon discussing as MK, Mahkamah Constitution, as a tool for the constitutional guarantee to prevent the rise of the authoritarianism. So both are very interesting for me. So, and my presentation titled "The Authoritarianism in the Post-Authoritarian Indonesian Constitution: Re-Emergence or Legacy." So that the title of this session is "The Asian Constitutionalism in Current Authoritarian Time." That implies that even Indonesia, how to say, are witnessing the emerging of the authoritarian. But we have to discuss what is the authoritarianism actually. So whether that the current Indonesian situation is authoritarianism or not, and also that if we consider that the current situation of Indonesia is at the beginning of the authoritarianism, we have to discuss about whether that the current authoritarianism is different or same from the previous authoritarianism. So, and this is my research concern so far, but I don't have the much adequate evidence about that. So that today my presentation today just discussed my very rough idea about this topic, and because of I already obsessed by my task as a vice dean here, so that I don't have enough time to make a good PPT slides. So please allow me to use my rough note about that. So first, I'd like to start from the introduction. Just remember the very early days of the Reformation. One of the most impressive views of Indonesia after 1998 for me was the red area in the bookstores, Gramedia, etc. So soon after the end of the anti-communist Suharto regime, many books on the Indonesian Communist Party, PKI, and its leading figures such as Musso, Sbandorio, Tan Malaka, etc., Amir Shafruddin, or the Suta Shafrer, that they are socialists, those and the translation of the socialism and communism that the Suharto government strictly prohibited were published. So, and this book is always use the cover, red cover, so that it looks that there is one red area in the bookstore soon after the Reformation. This is very impressive for me. And moreover, there were active critical argument on Panchashila in mass media, political and academic arena. This view means that the national ideology issues, once monopolized by the authoritarian regime, has been opened for everyone. Everyone can discuss what is a Panchashila, whether Panchashila should be maintained or not, something. However, around 2010, more than 10 years since the beginning of the Reformation, the situation completely changed. Panchashila is enshrined as a sacred, inviolable ideology again, and the atmosphere of open discussion on the meaning and the status of Panchashila drastically shrunk. Various academic conferences that also I attended and academic papers published in Indonesia used the Panchashila as a part of their title and assume it as an unconditionally given ideology that is not subject for the critical evaluation. We must start from the Panchashila, and we cannot discuss about the Panchashila anymore. So, however, a stark difference existed between the indoctrination of Panchashila in the Suharto regime and the current treatment of Panchashila. Suharto regime defines the meaning of Panchashila so that it supports the regime, for example, as P4. Various laws, imperial decisions, and the court decision had confirmed such a definition of the Panchashila. In other words, the Suharto regime monopolized the authority to interpret what is a Panchashila. In contrast, at least now, none have such a monopolistic power to define the content of Panchashila, while Panchashila itself is considered as an absolute truth. The lack of the superior interpreter of Panchashila forms for me, a unique condition of the post-authoritarian Indonesian constitutional politics. To discuss the post-authoritarian constitutional politics mentioned above, this paper will review how the violation against the Panchashila has been defined in Indonesia. For that purpose, the next section will review the judicial decisions on the offense cases against the anti-subversion law. It's a very, nostalgic, it's a very old law, already abolished. But I think that the anti-subversion law is the only law which, apparently penalize the behavior against the Panchashila. So, even that in the authoritarian regime. Then in the third section, this paper will refer to the amended law on the mass organization. So the law and the last part will argue how the vaguely conceptualized Panchashila as an absolute state value has a chilling effect on the freedom of thought and democracy. Okay, let's move to the subversion law. So what are the activities opposing Panchashila in the Suharto regime in the case of anti-subversion law? It is useful if we consider about the Panchashila. What activity or behavior or thought considered as anti-Panchashila, and we can compare with the previous authoritarian regime and the current situation. So, and as I said, that the anti-subversion law enacted in 1963 is penalize the behavior of anti-Panchashila. So, Other oppressive regulations such as a hard-side article in the criminal code, it's used more, how to say, modern style. But the subversion law is that, how to say, penalize purely the idea that against the Panchashila. So Article 1 of the anti-subversion law provides that anyone shall be punished if the person intentionally or obviously assumed intentional or knowing that the result or obviously assumed knowing the result conducts such acts, destroying, damaging, or deviating the Panchashila state ideology or broad guideline of the state policy. GBHN. So the anti-subversion law was a useful legal tool for the past authoritarian regimes in Indonesia to oppress the political dissent. Because of its value definition, the act against Panchashila state ideology is the most frequently used reason to criminalize political dissents. Though it was the Skarnov government that enacted the anti-subversion law, the Suharto government also more actively used the anti-subversion law. So, and I'd like to review some cases of the anti-subversion law. First, I'd like to start the PKI cases. Soon after the September 30 incidents, the former Indonesian Communist Party members who engaged in the armed resistance in the remote area were tried in the court for violating the anti-subversion law. In the series of trials, such as I collected the cases in the district court when I studied in Indonesia. In series of trials, the court decided that the mere participation to the Communist Party or non-violent propaganda activity for the Communist Party constituted the subversive crime, because the object of the PKI was to overturn Panchashila by establishing the communist regime. So, and the next case is about the Islamic radicals. In 1970s, the government repressed the political movement of the Islamic groups called the Commando Jihad. So, and the Bojonegoro District Court decided that to constitute the anti-subversion crime, the use of violence is not necessary, and it is enough if a person recognizes the possibility of damaging Panchashila. Furthermore, the decision continues that the accused should know there was no legitimate state ideology other than Panchashila. Therefore, the decision continues, being a member of the organization aiming to establish an Islamic state is the act of destroying Panchashila. The decision of other decision reasons that the establishment of such an organization was a subversive act, and the committing robbery was not the main reason for the conviction. And another decision further found that defendants who failed to recruit new members still guilty of subversion act. So that those decisions declared that there was an uncompromising contradiction between Panchashila and Islamic State, and the replacement of Panchashila by Islamic State is an idea. This idea itself is a wrong interpretation of Islam and anti-Panchashila. So, and the next case is a separatist group in Aceh and Papua. Regarding Aceh, the Loksmawe District Court decided that the sympathizer, not the armed guerrilla of GAM, because the political purpose of GAM itself is destroying Panchashila by establishing the authority as a legitimate government. And as for Papua, that district court this found guilty of the student member of the pre-Papua organization who didn't engage in the armed activities for the subversive act. According to the decision, the accused knew the Panchashila, especially the unity of the state, and participated in the activity distributing the anthem and the tentative constitution of organization. This constitutes the anti-subversive act as well. Okay, and the next case is more peaceful activity, the democratization movement cases. The above cases, PKI, Commando Jihad, and the separatist movement, those cases confirmed that the use of violence was not the condition for the anti-Panchashila activities. Thus, purely peaceful activities had been penalized for the subversion and the anti-Panchashila. The first case is a conviction against General Dalsono, who was accused for subversion for publishing the so-called white paper of Tanjung Priok incident. The court decision says that the criticism against the governments through the white paper did not take a constitutional way based on the Panchashila democracy. In other words, because the accused did not trust the issue to debate based on the family principle in MPR and DPR, and the way of criticism of the white paper is the behavior based on the liberalist culture, which is contradict with Panchashila. The second one is the so-called Kelompok study case. Its the main place is Yogyakarta. The Supreme Court's decision combines that accused who criticize the economic policy and the undemocratic nature of the government in the small study group for a subversive act. The decision reasoned that even criticism from the society was necessary, but the objection must be made in a way not contradict Panchashila and the Constitution. Furthermore, according to the decision, the opinion of accused is influenced by the Marxism and Leninism through the novel of the Pramila Anantatur. The third case is regarding the People's Democratic Party, PLD. The Supreme Court decided that the mobilization of rebels and students to the demonstration organized by the party possibly destroyed Panchashila and gave her end. So that those cases indicated the broadness of the notion of anti-Panchashila under the anti-subversion law. So how about now? So I'd like, in this section, that I'd like to discuss about the post-authoritarian constitutionalism and the mass organization law. Among various legal products during the Suharto regime, the so-called 5 political laws in 1985 are known as a legal tool to sustain the authoritarian regime. The 5 political laws are the general election law and the parliamentary law and the political party law and the referendum law and the mass organization law. All of them are enacted in 1985. So, and the first 4 laws, that the general election, parliament, and the political party and the referendum law were abolished or entirely amended after the end of the Suharto regime. However, only the mass organization law has been untouched until amended by the law in 2013. I just noticed about that, and I rather surprised about that. So I thought that the mass organization law in 1985 already abolished, but actually it's still sustained, survived. While the single umbrella organization rule, this is the most severe risk for the freedom of association during the Suharto regime, is not applied as strictly as the previous regime. However, the prohibition of anti-Panchashila organization and disbanding order remain unchanged until now. It is a legacy from the Suharto's authoritarian regime. The law 2013 and the law 2017 amending the mass organization law formally abolished the single umbrella organization rule. However, interesting rule, that still that those laws tighten the restriction on the organization that assumed as anti-Panchashila. So I'd like to consider about the implication of the legacy of the previous regime reflected in the mass organization law. So in order to that, I will refer to the notion of the Indonesian value or Indonesian and the concept of illiberal constitutionalism. What is the Indonesian value? That in the Punjurasan part of the mass organization law in 2017 referred to the Bangkok Declaration of Human Rights in 1993. This declaration was adopted in Asia Pacific Regional Parliamentary Meeting for the Vienna International Human Rights Conference in 1993. So, strangely, the reference to the declaration is written in English and not the full quotation from the original text. I don't know why that this Punjurasan used English. I couldn't find any information about that. But anyway, around the time of the Vienna conference, the controversy over the human rights concept between the West and the Eastern countries had heated. The Bangkok Declaration is an open collective refutation of Asian authoritarian countries against the criticism of their poor human rights record in this region. The declaration clearly claims that each state has its own socio-cultural value and human rights based on it. That's why the Western countries shouldn't force non-Western countries to accept their value, including the human rights. So that this argument is called the Asian value argument. But this Asian value argument doesn't have the adequate theoretical foundation, and it was no more than a self-legitimation of domestic human rights restriction by the authoritarian regime in Asia, including Indonesia. As discussed in the previous section, a value played a significant role in restricting anti-Panchashila organization by anti-subversion law. Subversion is not the crime of violence, but the crime against the value contained in Panchashila. Furthermore, as indicated in the trial of the General Darsono or Krompok study and the PLD, the subversive act is the act against the mode of behavior and thinking that is consistent with Panchashila value. During the Suharto regime, the government monopolized the authority to decide what the Panchashila value meant and what activities were inconsistent with the value. Thus, the argument about the meaning of the value was closed for others, and any opinion that raised doubt about the government's interpretation was restricted and sometimes criminalized. The Suharto regime referred to the story of good traditional Indonesian society to explain what Panchashila means. For example, that the family principle, asas keluargaan, or gotong royong, or integrated state, negara integralistik, have been presented as a reality representing the Indonesian value or ke-Indonesiaan. However, in fact, the main part of those concepts is imported from the European political legal ideas, such as the historical legal school or organic state concept during the pro-independent nationalism period. The article that prohibits anti-Panchashila activity in the mass organization law indicates that the post-authoritarian Indonesia still holds the legacy of the authoritarian regime. So, and in order to analyze or discuss about this point, I'd like to refer to the concept of the illiberal constitutionalism. How does the emphasis on the Indonesian value affect on the post-authoritarian constitutionalism? So, according to the illiberal constitutionalism, there is a distinction between the liberal constitutionalism and the illiberal constitutionalism. And the illiberal constitutionalism gives the priority to the specific values such as ethnicity, communal morality, religion, or political ideology, and actively promotes such a value considered as a good one, common good one. In contrast, liberal constitutionalism recognizes the individual autonomy and the neutrality of the state. From this viewpoint, the Constitution of 1945, which provides the Panchashila as a state ideology, has the characteristics of the illiberal constitutionalism. While the liberal constitutionalism doesn't necessarily result in the undemocratic regime, communitarian and theocratic, according to the Theo, that the communitarian and theocratic constitutional order in their search for identity and authority may not sufficiently restrain the abuse of public power, or articulate the substantive articulation of the good and common life, which is satisfactorily inclusive. Therefore, while the amended Constitution of Indonesia guarantees the human rights and the restriction of executive power far stronger than before, the Constitution, Indonesian Constitution, still contains the vulnerability to authoritarianism. It is especially dangerous if the opportunity to argue the meaning of the ideology, Panchashila, and the common good is closed for others. So from this viewpoint that I just showed some comments. Now, according to Indonesian constitutional political history, the arguments on the Panchashila has not always been closed, especially if we see the history of the parliamentary democracy before the return to the Undang-Undang Dasar 45. So at that time, that there is a very free, open argument about what Panchashila means. However, the previous regime, both Sukarno and Suharto, successfully monopolized the authority over the Panchashila and realized the authoritarianism that oppressed the political dissents. And as
Professor Yuzuru, I'm sorry, you only have 3 more minutes.
Okay, I will finish. This is the last page. As cases regarding the anti-Panchashila activities in anti-subversion law, the anti-Panchashila activities have been defined widely, from the apparently armed organization against the state to the mere unfavorable opinion for the government. Even though the security laws such as the mass organization law is restrictively implemented so far, the potential risk of arbitrary use of anti-Panchashila remain high. While the current constitution provides the freedom of opinion, the ambiguous meaning of Panchashila value and the lack of the open space for discussion on the state ideology shall have the chilling effect on the freedom of expression and association. Therefore, the emerging risk of the authoritarianism in the post-authoritarian Indonesia is partially the result of the legacy of the authoritarian regime that made Panchashila an unquestionable absolute value in Indonesia. So this is my still just a hypothesis and rough idea. So I welcome your comments or questions to elaborate my idea. Thank you very much.
Thank you, Professor Yusuru. Yeah, that's a lot of things that actually Professor you talking about here, the authorism in the post-authority Indonesia constitution, premature or legacy. And here he point out that actually the anti-Pancasila activity, there's a lot of happening in Indonesia, such as the PKA, Islamic Radical or Islamic State or separatist group that actually trying to change the Pancasila ideology, that actually Pancasila itself, this like a gift, become the ideology, unconditionally given ideology for Indonesia. Therefore, the point of view that the article that prohibit anti-Pancasila activities in the mass organization law indicate that the post-authoritarian Indonesia still hold the legacy of the authoritarian regime. Therefore, the emerging risks of authoritarianism in the post-authoritarian Indonesia is partially the result of the legacy of the authoritarian regime that made Pancasila an unquestionable absolute value in Indonesia. So thank you for all of this speaker, Professor Melissa, Professor Simon, and Professor Yusuru. We will go to the next session for question and answer session. We have a lot of questions here. Maybe I will read one by one. For the first question in the chat box is from Al-Farabi. The question to Professor Simon. My research suggests that judges from the State Islamic Court tend to incorporate the Constitutional Court judgment that attend to the establishment practice in the Islamic Court, but they otherwise object to fully incorporating such judgment. For instance, they can easily adopt the Constitutional Court judgment on restricted polygamy and broken marriage ground, since the judgment predominantly reflect their tradition. On the contrary, they set certain conditions toward the legalization of a filial status of the child born outside the wedlock to his or her biological father, according to the establishment development on isbat nikah, even if the Constitutional Court did say anything about such condition. In this manner, the Islamic judge attitude shows the autonomy of the judge, but it may threaten the legal unity since the Constitutional Court is also part of the judiciary. Could you please give your comment on this trend, in particular with regard to the idea of the legal unity? And maybe Professor Simon.
Yes, thank you very much for a very good question. The question of the structure of the Indonesian judicial system is one that has perplexed a lot of people over time. I know Melissa Crouch has written a book about the Indonesian courts, and all of the different branches of the judiciary have separate chapters in that fantastic book. One of the I suppose, accidents of history in Indonesia is that the Constitutional Court was set up as a separate judicial institution from that of the Supreme Court. And I don't think it's unfair to say that when the Constitutional Court was established, the Supreme Court's reputation was not very good. And it was thought that if, for example, constitutional functions were not given to a new court, but rather were given to the existing Supreme Court, then its decisions might not have been credible, and much, of course, depended on having an independent institution to enforce the newly amended constitution in the post-Suharto era. I'm thinking particularly of all those human rights that are in the constitution. If you left them in the hands of the Supreme Court, then it's possible that the rights might not have been enforced, for example. So we have two separate systems. Of course, we also have separate systems in many other countries, particularly civil law countries, which have constitutional courts as well that are separate from other judicial institutions. But one of the issues in Indonesia, which this question relates to, is that because these decisions or these courts are parallel systems, and because there is formally necessarily no system of precedent, even though constitutional court decisions are theoretically supposed to apply generally to all, sometimes the courts of Indonesia don't necessarily comply with the letter of those decisions. And there are several examples of this happening, one of which thank you for alerting me to, the person who asked the question has raised. In this case, the religious courts. So if I understand the question correctly, what we have here is examples of the religious courts, in essence, picking and choosing what parts or cherry picking parts of constitutional court jurisprudence they want to apply and modifying constitutional court jurisprudence that they might not want to apply. Now, the main weakness in the Indonesian judicial structure that I just explained is that there is no court under the jurisdiction of the Constitutional Court to make sure that the religious courts or any other court complies with the Constitutional Court's decision. Someone might want to appeal a religious court decision that seems to ignore a Constitutional Court decision, but they would only be able to appeal it to the Supreme Court, which, as I said, operates in a parallel jurisdiction to the Constitutional Court. And there are several cases, as I've just said, where the Supreme Court hasn't complied with necessarily precisely what the Constitutional Court says in its decisions. So that is my answer, I suppose. It would be good for there to be clarity. And I see there's a question about the amendments to the Constitution coming up soon. It would be good for there to be clarity in the jurisdiction of the Constitutional Court, and particularly the obligation of other courts to follow its decisions, because it's currently a little bit unclear. I think also what's interesting that arises out of this question is the problems that arise from conditional decisions, because essentially what is happening here is the interpretation of the Constitutional Court's decision is being left to the religious courts, and they're doing what they think they should do. Perhaps if the National Parliament had followed up on the Constitutional Court's decision, say in the case about marriage, children born out of wedlock, perhaps there would be more clarity, and the religious courts might be required to follow that line more clearly or more closely. But I'm speculating because there is no such legislative response, as I said in my presentation.
Thank you, Professor Simon. For the second question from Mirza Buana, question to Professor Melissa. The strongest influence for military takeover around the globe since World War II is Samuel Huntington Brooke. My question is brief. Is there any academic counter-narrative that can convictionally tackle Huntington Brooke on political institutionalism in a post-authoritarian countries? And is there any good practice of constitutionalism in a post-authoritarian military countries that can substantively tame the military? Professor Melissa?
Thank you for the question. I mean, first I would say I think someone like Samuel Huntington as a political scientist sometimes comes at these questions from a different point of view to scholars of legal studies. And certainly there are many people who disagree with Samuel Huntington's views. I think what I would say is that the point in time we find ourselves in history with this trend around the world towards democratic decline and the decline of constitutional democracy. I think it is a reminder, first of all, that the transition from authoritarianism to constitutional democracy is not necessarily a linear one, nor necessarily an inevitable one. So, you know, that countries do fall in and out of authoritarianism, that there is a possibility of reversal or decline, and that we, if we're interested in a normative sense in thinking about, well, what are the ways in which we can prevent this, I think we still have a lot of work to do. We don't know the answers in terms of to what extent legal and political frameworks and ideas can help to prevent or to minimize the decline of democracy. Of course, there are, you know, examples of some countries that have been, you know, perhaps more successful than others, and I guess examples of very different ways of doing things. So in contrast to Myanmar, you could, you know, look at a place like Chile and the way in which, despite the fact that it chose to retain its constitution that had been a part of the authoritarian military rule, it was still able to make a transition. I think the interesting thing now is that we're only just now seeing, several decades later, that there is a desire among people in Chile to draft a new constitution. And yet that wasn't something that was part of their initial transition to constitutional democracy. So I think it's clear that it is entirely possible, as the case of Chile suggests, that you can transition to constitutional democracy without necessarily having to draft a new constitution. But I think we're all quite interested at the moment in following that example, just because effectively it appears they've delayed that process of drafting a new constitution to embody some of the hopes for ongoing democratic future, I guess. I'll leave it there. Thank you.
Thank you, Professor Melissa. Next question from Pirisca. I want to ask to Professor Simon and Professor Yuzuru. Nowadays in Indonesia, there is a strong political movement to amend the constitution with several reasons. Do you think with this pandemic situation, the amendment is urgently needed? Thank you very much. Maybe Professor Yuzuru first.
Okay, thank you. It's a very interesting question. And just for your information, that Japan has just had a general election a week ago, and LDP, the ruling party, keep their seats, majority seats in the parliament. So, and at that time, that according to the public opinion survey, the only 5% of respondents answer that the constitutional issue is important for their voting. So, and other people say that the great majority of people doesn't care about the constitution, even though that the LDP, Liberal Democratic Party, strongly claim the needs for the constitutional amendment in Japan. So maybe that in Indonesia as well, for the ordinary people, constitution is not urgent matter for their life. Maybe even the ordinary people consider the law is important for them, but for the ordinary people, the importance of law is just for the how police act, what decision made by judges, or what the government produce the legal product regarding the tax or other more directly related to their lives. So maybe the constitution is not the urgent matter for the ordinary people, except the member of the DPR. So this is the one thing. But in order to answer this question, that we also think that what amendments are demanded. So, and as far as I know, that the demand for the amendment is regarding the revival of the GBHN or the enhancement of the status of the MPR. But both things is not how to say, you know, that consistent with the current constitutional system in Indonesia. The status, the superior status as a practice, the exerciser of the people's sovereignty, this model was taken from the Soviet constitution in the early 20th century, and also this socialist constitution as adopted by the Republic of China and also the People's Republic of China. And upon the independence of Indonesia, there are not so many constitutional models that it's fit for the Indonesia. So, and that's why that the Suharto and other nationalist leaders choose the Chinese constitution as a model. And according to the Chinese constitution, the MPR in China, that they have the same organization, which represents not only the political representative, but the representative from the other fields, that this regional representative and the functional representative. And those has the MPR or similar organization which have the which represent such a various field can, how to say, you know, that can represent the people as a whole. That according to the Sukarno and other nationalist leaders, that the DPR is only the political representative. That's why that they cannot exercise the people's sovereignty. But if an organ represents the whole population, they, how to say, they have the legitimacy to represent the people's sovereignty. So if that now that the MPR composed from the DPR and the DPD, both are political representative, and if MPR should have the, how to say, the superior power than DPR, so that it's that contradiction, that because that the MPR cannot represent the other than political interest. That's why that the introduction of the GBHN or the, how to say, that puts a superior position of the MPR is how to say, it's not consistent with the current constitutional system. That actually that the constitution before the amendment and after the amendment is completely different constitution in terms of the constitutional system. So if the constitutional system is very different, how to say, revive the some old system, that just result in the inconsistency within the constitutional system. This is my answer to the first question and additional explanation. And should I read the second question about the 30 September incident?
Maybe later, Professor.
Okay. Okay.
Maybe go to Professor Simon first.
Okay.
Yes, thank you, Professor Shimada, and thank you for the question as well. I know Professor Shimada has really already said a lot about this question, so I don't want to add too much more, except to say sometimes constitutions can be changed on a whim to solve very short-term political problems, or in the face of very kind of short-term thinking. For example, there's very little impetus to change a constitution, to change the number of terms that a president can serve, unless a president is about to complete his or her last year or two in office. Of course, Professor Shimada talked about the potential to reimpose the GBHN, but also, of course, a proposal has been floating around for a long time as to whether the number of terms a president can serve should be extended or all limitations removed. I guess one thing I would say, in addition to the fact that constitutions are long-term documents, they can be amended, of course, but they should take into account what is happening in a particular country. But sometimes they're seen as a solution to short-term problems. I would also say that one of the reasons why Indonesia's constitution has not been amended since 2002 is a fear that if you open the door to constitutional amendment, one never knows what visitors you might have. If you open the door, what debates are going to transpire, what new demands are going to be put forward. I think it would be a mistake to have constitutional amendments done quickly and behind closed doors and without public consultation, which is unfortunately the way that the National Legislature has been acting on controversial bills lately. It must be open, it must be subject to public debate, it must be a long-term project. As it was, it took 4 years from 1999 to 2002. And there were lots of debates, many of which have been recorded, and many of which the Constitutional Court, for example, still refers to in its decision. So, again, the Constitution is a pretty special document. It means a lot, particularly in Indonesia. So there must be a lot of care and attention and spotlighting of the process or on the process if it were to occur. Thank you.
Thank you, Professor Simon. For the next question from Mirza Buana, question to Professor Simon. I think obeying the court decision is merely an issue of constitutional or rule of commitment. My question is brief. Do you think condition decisions are effective to shoot the tension between the court and the government? And the last question, are the strong review and strong remedy possible to the Indonesian Constitutional Court, or the compromise decision is really inevitable?
Thank you. I feel very rakus, very greedy, taking up most of the time and having most of the questions, but also very honoured. So just let me try and deal with this one, Mirza, as quickly as possible. Do conditional decisions soothe tensions between the government and the court? Well, initially I thought they did. Initially, that's what I thought they were designed to do. Initially, more than 10 years ago, when the court was just established, I thought that it was one way of the court making a point about the constitutionality of the legislation it was reviewing without being seen to be going up against the government by invalidating laws. And I thought that the Constitutional Court did this because it didn't want to invite a backlash by the Parliament, particularly if members of the government could pass a regulation that could have the same effect as the laws that the Constitutional Court invalidated. The Constitutional Court, I think, could see the future and its place in the constitutional system of Indonesia would not have been particularly strong if the government took that kind of approach to the court's decision. So I think that's one of the reasons why conditional decisions were used initially in Indonesia by the Constitutional Court. But now I wonder whether the Constitutional Court is going a bit too far. Now I wonder whether there needs to be a much bigger debate, bigger discussion in legal circles about the fact that when the Constitutional Court issues conditional decisions, it's not just creating tensions between the government and the court, it's actually, I think, effectively passing new laws, or by changing provisions of laws, making them unconstitutional unless interpreted in a very specific way that the court specifies in its decision. So I actually think it's problematic from a separation of powers perspective, because we have a court rather than acting as a check on, or in addition, I suppose, to acting as a check on government power, reserving for itself power to change legislation as well. I think that's quite problematic, at least in the absence of some open debate about this. I've recently read the thesis of a constitutional court judge, I think Siahan, who admitted that conditional decisions were the same thing as creating new law, creating new legislation. But I don't think that the court officially recognises this, even though sometimes it seems to kind of hint at it in its decisions. Is strong review possible in Indonesia? Some would say it already has been in some cases. In others, maybe not so much. But really, this is I think, quite a political question in the Indonesian context. And this goes back to the point I was making in my presentation about compliance being at least partly affected by the political and public capital a court has. The more capital it has, the more likely it is that it can make a decision that is strong form without receiving too much backlash from the government. So yes, I think strong form review is possible, and in some cases we've already seen it happening in Indonesia, but in other cases perhaps the court has been a bit more restrained, particularly when its social or political capital has been low.
Okay, thank you, Professor Simon. For the last question to Professor Yusuf Simada, from Billy S.R. Inditya, I want to ask about the 30 September PKA incident from your perspective, sir. The possibility that was a military coup that got back up from US in the heat of the Cold War and blaming PKA issue for scapegoat, maybe, for stepping the red. Thank you very much.
Thank you very much, Billy, about the question. And honestly speaking, that I cannot answer this question because it's not my expertise. So, and maybe some people, of course know that some people claim that Daran, that how to say, manipulator of this incident is the United States or CIA. But I don't have any tool, any evidence to, how to say, prove or to discuss about the issue. So, also there is a question from the East Timor. Thank you very much. That obrigado. So, and about the PKI. That, but at least that because how to say September 30 September incident, the Suharto government successfully manipulate or monopolize the notion of the Panchashila by emphasizing the cruelty of PKI, so that if someone doubts about the legitimacy of the Suharto government's version of the Panchashila interpretation, they are blamed as a PKI communist, or how to, that as a jihadist or something, that how to say radical Islamist. So, and everything that who oppose to the government policy, they are blamed as anti-Panchashila, because that the government always can say there is a risk or danger of the PKI. So maybe this is one effect of the 30 September incident for the Suharto regime. So that's all I can say for now about this issue, that I don't know about the real history of this incident. So, and I think that this is the answer for the Antonino from Timor-Leste. So, so thank you very much.
Yeah, thank you, Professor Yusuf. That's all for today. Question and answer, also the summarization of the first session from the team Asia Constitutionalism in Current Authoritarian Turn. Thank you so much for Professor Melissa Crouch, Professor Simon Butt, Professor Yuzuru Shimada. I'm so sorry if I pronounce your name wrong. I'm so sorry about that. And thank you so much for all of the participants coming today. And after this, there will be the panel session for panel 1, 2, and 3. And thank you so much for everyone.